scooters, they're great when you're on them and you're upright, but if you're in a jam, you're in trouble. Similarly, if you're collected by one of these scooters as a pedestrian and you're injured, regardless of what state of Australia you're in, getting compensation for those injuries is largely a no-zone area. In the 18 months leading up to May 2020, 797 people were hospitalised after being injured by a hired or privately owned e-bike and other types of motorised things. On the Gold Coast, 100 people were hospitalised with e-scooter related injuries in 2021, and you can bet your bottom dollar that those people are forking out money out of their own pocket for surgery and treatment, not to mention days and potentially weeks or months away from work. Here's the thing. You as the rider of one of these has a contract between you and the company that owns them. And that contract is long and very, very complex. But ultimately, across all these scooters, it gives the company an out in so many different circumstances. For example, Beam, a notable scooter company, says the company isn't liable to users for any death, disability, or personal injury, howsoever caused, arising directly or indirectly in connection with the use of its e-scooters. It's a true story. So you might say, well, if I'm barreled by one of these as a pedestrian, I'll sue the rider. Well, good luck with that. Needless to say that this is an area that needs reform on multiple levels. The best advice I can give you if you are injured on one of these things or by one of these things is to seek legal advice, because you never know. There may be something unique about your circumstance that warrants investigation and potentially might launch a claim. If you need help, you can drop by lawbydan.com.